Welcome to the National Crime Victim Law Institute's online toolkit. Toolkits, which include a combination of videos, downloadable resources, and other interactive exercises, are part of the larger universe of resources that NCVLI offers. In addition to these toolkit resources, you can visit NCVLI's website at www.ncvli.org to access additional free resources, including a number of in-depth articles in NCVLI's Victim Law Library. You can also visit our website to request additional technical assistance and trainings on victims' rights-related topics.
We're going to focus in narrowly on getting heard before a plea, right? Before the case ends, essentially, in many ways. We're going to try and cover three things. We're going to get to the end of this session and be able to recognize at least three rights that are implicated in plea process. Please note, it's a lot of intentional wording there. Plea process, not just plea. Okay, second thing, be able to articulate three legal arguments to ensure your client's wishes are meaningfully considered in the plea, right? Again, that's the apostrophe. What does your client want? How do we make sure that's meaningfully considered? And then number three, designing a plan for preserving a record for appellate challenge. That's going to be our last piece, and it's going to be really foundational like all of this, but we're going to get through all three of those pieces focused on plea. Okay, so why are we focusing on plea bargaining, right? So this next slide is just an image. And on the right-hand side, that image that is there, before I describe it, those of you that have visual capacities to see what's on the screen, describe what is on the screen. Let's see how you describe that right visual image on the screen. Foggy, unclear, cold, steamed glass, condensation, blurry. Perception is always accurate, right? Because we're all experiencing that image ourselves. Some of you might end up putting in, well, it's blurry, but there's trees. I can kind of make out trees. Or blurry, but there's light behind it. Some are saying it's wet and rainy, maybe trees. Someone says, I can see something, right? This is a metaphor for the plea process. This is the plea process. It is confusing and foggy and behind closed doors. And yet it is sometimes the whole thing. And what I mean by that is the research is clear and the data is clear that 94 to 97% of state and federal criminal convictions result from plea bargaining. 94 to 97%. And yet it is foggy and unclear and happens behind closed doors and on telephone calls between prosecution and defense attorneys, often not even with the defendant themselves, the accused themselves, until the attorney passes it on. It's this hidden part of the criminal legal system that we need to, and in the next 45 minutes together, peel away some of the fog, peel away some of the layers, because for survivors to participate in the legal system, they have to be in plea. And the quote on the screen, criminal justice today is for the most part a system of pleas, not a system of trials. Just remembering that helps us know why we have to be in the mix. So then you might be asking, okay, so great, I just need to be in at the plea, change of plea moment, right? Well, we're going to back you up just a little bit more on this next slide, which is this wonderful image that Amy found, which is expect the unexpected, right? Not only can plea happen at any time, right? Which we have an image of an apple on the outside, but it's an orange on the inside. When you slice it open, that's what's on the screen. You have to always be expecting the unexpected. And that can mean that the plea changes. It can also mean that there is something that's happening before charges happen. So charge bargaining, or whatever vocabulary others of you share in the chat for what happens in your jurisdiction, that's what happens when before you even file charges, before the prosecution or the state files charges, they're already negotiating. They're already negotiating with the accused. Oh, if we bring this charge, would you plead to it? Oh, okay. Now, often it happens in big environmental cases or corporation cases or high profile cases, right? The Jeffrey Epstein case. Most of us have heard about that one. And the fact that there was negotiation before there were charges filed, and that resulted in excluding the victim. We've seen it in environmental cases out of Texas, BP Petroleum. Right? We've seen these things that happen, but it doesn't only happen in high profile cases. So one of the reasons we're bringing this up is because plea is such an important part of the case, and because it happens early, sometimes even before charges are filed, our role as victims' lawyers to make that apostrophe meaningful is to get in from the beginning. And the question is, well, why? Right? What's so important? So we're going to ask you to use the chat. What are the possible outcomes, thinking about it kind of from your victim's perspective, of your client's perspective, of a plea bargain? What might happen to the case as it relates to your victim if a plea bargain happens, right? What are the outcomes of the case? We haven't given you any facts, so this is big picture law. Use the chat. What might happen to the case? It might go down to a misdemeanor from a felony. The client could be totally left out of the process. Lighter sentences, right? Lesser charges, victim's voice not heard in court. Loss of opportunity to be heard. Really a nitty-gritty one, sex offender registration, right, may not be on the table anymore because of the way it gets charged, right? Or the way it gets pled, excuse me. Cases get settled, right? Okay, absolutely. Here are some things that we've identified that can be outcomes of the plea, right? Case could be dismissed altogether. It could result in a deferred prosecution, right? Which is essentially, oh, hold on, victim, let's see how the accused does, which might be what the victim wants, but it might not be. Charges could be dropped or reduced, deferred sentences, which means basically, right, the defendant gets a chance again and maybe no sentence gets imposed. That could be exactly what the victim wants or not at all, right? Reduced sentence, sentence for time served, probation, then all of the ones that you identified. There are so many possible outcomes from a plea, all of which should have the survivor's voice in it. So we're framing this to say, if you are starting to represent victims, this needs to be one of the first things you are turning towards. What is the chance of plea, and how do I start talking to people in the system about, I want to be involved. Not only I want to be involved, I have to be involved. Okay, so with that, I'm going to turn it over to Amy to start leading us through some detailed parts.
Thank you, Meg. So Meg set up the critical importance of the impact, right, of a plea process on the victim's case. Let's talk about the actual rights that might be implicated. And when we think about rights that might be implicated, we want to think broadly beyond just the two moments that might be the most obvious, right? That the plea deal itself or the plea hearing, because more than those moments in time are really at stake, right? Rights that might be implicated at the outset. Think of what Meg just mentioned in terms of charge bargaining, right? Sort of the before charging even takes place, some of the negotiation and bargaining could have some serious impact on the victim's rights. So now in federal cases, right, let's just start with federal. In federal cases, the Federal Crime Victims' Rights Act applies, and we've highlighted some of the rights that might be implicated. So at the very outset of a case, right, even before prosecution, we have the right to confer with the prosecutor, right? That's definitely at play. Right to be informed of deferred prosecution agreement. That's what that happened in the Epstein case that Meg mentioned. And of course, plea bargaining. And the right to be treated with fairness and respect for a victim's dignity and privacy, right? But beyond that, you have the more obvious rights. By obvious, I mean, facially you look at them and you're like thinking, oh, plea, right? So the notice of the proceeding, right to receive reasonable notice, the right to be present and to be heard at that proceeding. Now, there are also some of the less obvious, and restitution is one that I'd like to go into a little bit more detail, right? Because on its face, a lot of times that doesn't jump out particularly to a new practitioner as to why that might be implicated right at the outset. So let's consider an example that a financial fraud case, right? Where the offender's conduct occurs over a 12-month period of time. And over the 12-month period of time, the regular acts cause a victim to lose $2,000 every month. So in that 12-month period, the victim suffers a loss of $24,000. And let's say by way of bargaining, whether it's charge bargaining, whether it's plea bargaining after charging will take place, the prosecution agrees to drop 6 months out of that 12-month period from prosecution, right? So in the charging instrument, they're only going to proceed with 6 months of those criminal acts. That potentially causes a victim to lose the ability to seek restitution for losses incurred in those 6 months that are now not proceeding to prosecution. So 6 months times $2,000 a month, we're looking at, right, $12,000. That is a significant financial impact for a crime victim. That has its own consequences. It could lead to the victim's inability to pay rent, to pay mortgage, to pay debt, such as car payments. And as we can all anticipate, that leads to other potentially bad consequences, right? So the potentially significant impact that the bargaining process might have on a victim's right to restitution, the fact that the statistics that Meg mentioned earlier means that the case will most likely resolve in a plea, right? 94 to 97%, and the important role that restitution plays in a victim's ability to heal and survive. That is just one of the many reasons, in addition to all the ones that folks had identified in chat earlier, for victims to have their own lawyers at the outset of a case, so that they can be ready to protect victims' rights right at the beginning. Now, just briefly on state law, most state laws, as I see many state law practitioners in our audience, and military law too, most other jurisdictions have very similar rights to that afforded under the Federal Crime Victims' Rights Act. Of course, some are more robust or less robust than federal law. Among some of the other additional rights that might be available, I want to flag the right to the presence of a support person at critical hearings. That's actually fairly common, and plea hearings fall within those critical hearings in victims' rights procedures, right? Now, think of a sudden and unexpected plea hearing, right? That pretrial conference or that calendar setting conference all of a sudden turns into a plea hearing. That also impacts the support person's ability to be present, and the loss of that support person can have a significant impact on the victim's health. So the takeaway here, right, when you're thinking about all the victims' rights that might be implicated by the bargaining process, it's really important to think about beyond what seems the most obvious, and then consider whether or not they might be impacted by any step along the way in terms of the bargaining process from the pre-charging stage forward. Okay. Now, beyond the loss of some rights by the bargaining process, the status of your client as a legal victim in the case is also potentially at stake, right? Because victims under victims' rights law are defined either by statute or by the Constitution. And so, for example, let's think about a multiple victim case. I think some of you mentioned multiple victim cases in an earlier session. Trafficking is a very common example where you have multiple victims in a case. Let's say that you represent only one of the victims in a multiple victim case. And as a result of the bargaining process, the prosecution agrees to amend the charging instrument and drop the charges specifically against your client, right? And in those instances, in that moment, right, once the charging instrument's amended, your client is no longer technically a victim for purposes of that criminal prosecution. And so this would be a devastating loss, right? To lose the ability to assert any of the crime victim's rights that would otherwise be afforded. So let's just think for a moment about what we learned, and we're going to think about this further in the context of a hypothetical. Okay, all right, let's look at this hypothetical. So in this hypothetical, the defendant visited the victim's home and broke the victim's wrist. Defendant's action also violated a pre-existing no contact order. Defendant is charged with misdemeanor assault. Victim incurred $5,000 in out-of-pocket medical expenses to heal the wrist. The jurisdiction has mandatory restitution for a crime victim who is defined as a person directly and proximately harmed as a result of the commission of an offense. Now, plea bargaining happens and it results in a deal whereby the prosecutor agrees to drop the assault charge in exchange for a plea of guilty to contempt of court. Okay. So let's say that you learn about the plea deal the day before the change of plea hearing. And assume, for the purpose of this hypothetical, that this jurisdiction has rights identical to the Federal Crime Victims' Rights Act, so all the rights that we talked about earlier. Okay. What are some next steps that you might want to take, given what you've learned about the potential rights that might be implicated? What are some next steps you might want to take at this point? Ask the victim what they want, then file a motion to assert those rights. Perfect. Want to litigate right away. Asking the victim, do they actually want to appear? Do they want to attend? Can they make it, right? So thank you for reminding all of us of that. What else might you want to do? Call the prosecutor. Speak with the prosecutor, right? And the defense attorney, right? Will they agree to a continuance of the change of plea hearing? Or you can demand it, of course, right? Demand that the victim wants to be present and heard, cannot make it, or you can't make it, and that they need to seek a continuance or else you're going to file, right? When we know in practice, courts are very open when the prosecutor and defense, when the parties move forward and stipulate to a continuance, so do it, right? And of course, filing. Helping the victim, thank you, understand the pros and cons of the plea as part of that discussion. Right? Asking for that meeting with the prosecutor, since this seems very sudden, presumably the victim is not aware, and having that conversation as well. So it seems like you really absolutely potentially need to have a continuance to have all of this, even having the conversation with the victim, having the conversation with the prosecutor in terms of the conferral right away, right? So some additional, please, continue to type in some of the additional thoughts here in terms of, potential next steps. Think about the timing of the motion, right? You just learned this, let's say you just got in and you haven't even appeared in court yet, so you might have some challenges with respect to the written filing. One thing would be physically appear during the hearing and make an oral motion. Yeah, sometimes victims' attorneys absolutely have to do that. That is definitely on the table. The other thing would be, in terms of the motion that some of you had addressed, in terms of what you're asking for, remember to ask for something beyond just the rights that are implicated by the plea process itself, right? We know in practice, it's really common in a lot of jurisdictions to have that change of plea occur at the same time as sentencing. Whether it's convenience or whether it's the common practice. And we want to remind the court and all the parties, they do not have to take place at the same time. They shouldn't take place at the same time, particularly when already we have rights at stake that are going to be lost potentially by just the plea hearing itself. Sentencing is a whole other, proceeding that has additional impacts. And so asking the court not only to continue and reschedule the change of plea hearing, but also to make sure that the sentencing is going to be set forth at some moment in time later on, right? Okay, we do this hypothetical and imagine yourself at a moment in time before you learn about that plea deal. Okay, so you have all the other facts. The plea bargaining is happening in the background. You don't know that it has happened yet. Now, what if you already had this training And you were to anticipate in advance, because you know the statistics, you know that the case is most likely going to resolve in a plea, and you want to prepare in advance. All right. So think about all that we talked about.
What were some of the things that came up for you? We're going to share a few of our ideas. So we're going to put those on the screen for you, and I'm going to spend just 1 minute walking through them. As Amy noted, like, we are doing the redo of the hypothetical of what if you anticipated a plea deal, and our recommendation, our very strong recommendation to you is you always anticipate a plea deal, right? That expect the unexpected slide from earlier that was the apple on the outside and the orange on the inside. That's every day in victim law, right? And so when it comes to pleas, we encourage you to file a notice of appearance with the court very quickly. Get in on the case. We know there are jurisdictions where clerks are still confused and some judges are still confused about what to do with a notice of appearance. Reach out for technical assistance, but let's get you on the record as being the victim's lawyer. Confer with the prosecutor immediately. Start the conversation early. Do you normally plead these types of cases? What's the range of what you normally plead, right? Because prosecutors have an obligation to treat similarly situated accused similarly. So we need to know, what is the office practice? What's the prosecutor going to do? Talk to the defense attorney. Oftentimes in our practice, we still, even as victim lawyers, defer to prosecutors to convey the conversation with the defense counsel. But be a lawyer's lawyer. Talk to the other lawyers in the case. Oftentimes, we can talk with the defense attorney and figure out what does the defendant need out of this? What does my client need out of this? And then we can jointly talk to the prosecutor, or we can talk to the prosecutor and say, hey, I talked to defense counsel, and here's what we're thinking, right? Do not leave your communications only to the prosecution. Along the way, ask to include your client in the plea agreement. And what we mean by that is, no matter what gets pled to, it's a contract, right? Contracts can include terms that include your client. So even if that charge gets pled away, hey, please be sure that restitution is still included, right? And this is really important. The citation off to the side, the C, for example, citation of 18 USC 3663A, A3, is talking about this, says that the court shall also order, if agreed to by the parties in a plea agreement, restitution to persons other than the victim of the offense. We have an explicit in under federal law, but implicitly under contract law in most jurisdictions, we can do this also. Consider asking for a continuance. Amy already covered that. And then just be prepared to file the motion. Start drafting that from the beginning. Get ready. Expect the unexpected. And so now let's move on and do the hypo one more time. One more time. Except here, it didn't matter you were prepared. It didn't matter that you had this training, because the gosh darn conveyor belt of criminal justice just kept moving, right? So here we are returning to the hypothetical. The plea was reached without giving you reasonable notice, the victim or you as their counsel reasonable advance notice. There was no opportunity to confer before the actual change of plea hearing. And it resulted in the victims being denied the right to be heard, to be present, and potentially to restitution. But on the screen, we're focused on heard and present. So what do? Right? What do? You do not throw up your arms and give up, right? You instead throw up your arms and say, are you kidding me? Here we go, right? After you talk to your client and say, all right, how are you feeling about this? What do you want, right? Do you just need this over and you're okay with this plea? Okay, then maybe I file a complaint some way with the prosecutor and with the court and with the system, and I try and change it for the next one. But if my client says, I just wanted to be there and I didn't get that, or they say, I wanted to say something and I didn't get that, or I don't know what I wanted, but I sure didn't want it to be taken away from me in advance, right? Because sometimes our clients don't know what they want until the day of, to the minute of. And so no one should take choice away before then. So what do, right? You craft a motion for reconsideration, for vacating the plea, whatever you want to call it. Becca was awesome in the first session today, being like, find out what your client needs, put that in the caption of the slide of your pleading and say motion for, right? That is just a brilliant way of thinking about this. So we need to seek a do-over, right? And the arguments we can include, the victim has standing, right? Federally, we know there's Article 3 standing. Every jurisdiction in the country has something similar, but if you meet Article 3 standing, injury, causation, redressability, you're going to meet standing in your jurisdiction, right? The victim has standing. The victim's rights have been violated. The plea does not conform to statutory requirements. That might be one that you can go check the statutory requirements for how plea had to happen. Often it will say the victim had to be notified, right? The plea is not in the interest of justice. Ultimately, courts across this country have a standard. The standard is you accept a plea only if it's in the interest of justice. So yes, you argue victims' rights, but you also argue substantive plea law, right? And that this is not in the interest of justice. You include in your motion practice that the remedy does not violate the defendant's rights, particularly against double jeopardy, right? And then I'm reversing the order a little bit of what's on the checklist. The second to the bottom, right, is also to remedy the rights violation, you have to do what? Withdraw the acceptance of the plea, vacate the plea, set the case for further proceedings. Think through your relief request very carefully and decide what you want. But know that you have some of these options, right? And if your client had a right and wanted to do something with it, and the plea happened, go in, right? Go in. And we, again, will be here to do it with you. So best practice is where Amy started us. Best practice is be proactive, not reactive, right? That the hypo part I got to do was the but hopefully you're always being proactive. You, from the moment of client retention, you are, what do I do? How do I do it, right? I'm talking to the prosecution. I'm talking to the defense. I'm talking to my client about what they want. And I've had lots of conversations with them about the 94 to 97% that's going to resolve by plea. If you know the statistics, your client should know the statistics, right? They shouldn't be anticipating a trial if the data shows otherwise. So be proactive for legally and for your client's sake. So what did we cover? And what do we hope that you got, right? What we covered in this brief time was at least 3 rights implicated. Amy actually had a slide with many more on it, right? But at least 3 rights implicated. Articulating at least 3 arguments to ensure that clients' wishes are meaningfully protected, and then designing a plan for the appellate record. Now, I didn't call that what I just put on the screen, right, about that motion, but when you do a good motion for reconsideration or vacation, you're thinking about appeal.
Thank you for participating in this online experience, and we hope you enjoyed it. If you enjoyed this tool and are interested in other victims' rights tools, please visit NCVLI's other Toolkit resources for additional interactive learning exercises like this video, in addition to other tools such as flashcards, tip sheets, and much more. One of NCVLI's key projects is the National Alliance of Victims' Rights Attorneys and Advocates, NAVRA. Using its updated website, www.navra.org, NAVRA connects people committed to improving the justice system by providing the practical tools they need to protect, enforce, and advance victims' rights. NAVRA's tools include searchable databases of sample legal pleadings, legal memos, and key case summaries, as well as in-person and online trainings, partner listings, and the Pro Bono portal, which matches attorneys with crime victims in need of representation. And in addition to these resources and others available on our website, NCVLI is ready to assist by providing additional research and assistance that is tailored to your needs. Please visit www.ncvli.org and navigate to the online form by clicking the Professional Resources tab and then selecting Technical Assistance. Thank you for joining us.